Welcome to this overview of trade secret law. I'm Professor Seth C. Oranburg from the University of New Hampshire Franklin Pierce School of Law. And over the course of 5 videos, we are going to cover the basics of trade secret law. Our 5 videos will include introduction to trade secret law, explaining why it exists and how to understand it generally. We're going to define what is a trade secret under American law. We're going to understand when a trade secret is misappropriated under trade secret law in America. We're going to evaluate how to protect trade secrets with contractual arrangements, and we're going to discuss what remedies are available for parties whose trade secrets have been misappropriated. So stay tuned for this 5-video series, and at the end of it, you should have a basic fundamental understanding of how trade secret law works.
What is a trade secret? In order for something to merit trade secret protection, it must qualify as a trade secret in the first place. Under the Uniform Trade Secrets Act, UTSA, which has been adopted by almost all U.S. jurisdictions, a trade secret has 4 or 5, depending on how you think about it, elements. A trade secret means information, including a formula, pattern, compilation, program device, method, technique, or process that derives independent economic value, actual or potential, from not being generally known to and not being readily ascertainable by proper means by other persons who can obtain that economic value from its disclosure and use, and is the subject of efforts that are reasonable under the circumstances to maintain its secrecy. Let's talk about each of these elements in turn. So first, what is information? Trade secrets are intellectual property, never tangible property. Information refers to knowledge or ideas. While information can be made tangible, such as by writing something like a customer list down in a notebook, the notebook is not the information itself. The notebook contains or memorializes the information. The information is the customer list. Virtually any information that is useful or valuable to a business can be a trade secret. In other words, the theoretical scope of information that can be protected by trade secrets is very broad. Even information that cannot be protected by other intellectual property law might still be protectable as a trade secret. For example, technical information that is not patentable because it is not totally novel might still be protectable as a trade secret if it's not generally known. The tricky thing about trade secret information regards compilations of information, or a mosaic theory of information. For example, the individual names of all of a business's customers is generally known because they're published in a phone book. None of the individual names are trade secrets, but the compilation of those particular names of customers who are interested in a particular product or kind of product, that can be a trade secret, provided that that compilation meets the other elements of the definition of trade secret. Second, what is independent economic value? Courts don't hold a clear view on this element. Scholars suggest 2 framings. Either the information would be economically valuable to another firm because it is valuable to the firm holding the information, or such information would be economically valuable to another firm for the same reason that the information is valuable to the firm holding it. It gives meaning to the word independent and fits with the core notions of a trade secret as having some type of value. In other words, a trade secret's economic value is probably independent if the trade secret can be transported from one firm to another firm and can be employed profitably by the second firm in the same way it was employed by the first one. This concept of the information being useful to someone else seems important to it having independent economic value. Courts, however, generally don't struggle to find that this second element is met. As a rule of thumb, the fact that the defendant found the information worth appropriating and the fact that plaintiff found it worth suing for the alleged misappropriation tends to show the information has independent economic value. Third element, what is generally known or readily ascertainable? The third element or the third and fourth-ish, depending on how you look at it, is that the information is not generally known or readily ascertainable. Although these two concepts are lumped together, analytically, it makes sense to break them up, since the second, readily ascertainable, is related to reverse engineering, while the former is not. Generally known does not necessarily mean whether it's known or not to the general public. Certainly if it's known to the whole world, it's generally known. But generally known can also include being known within a particular industry or technical discipline. For example, most people on the street, so to speak, would not know whether a kind of adhesive is used to construct a solid-state hard drive. But if technicians in the hard drive industry know that a two-part accelerator-cured epoxy is used in this process, then that information is probably not a trade secret. The readily ascertainable prong boils down to the fact of how easily a trade secret could be independently discovered. Note that this does not require the information to be actually discovered. Rather, the question is whether the information is easily discoverable. Not readily ascertainable is not quite the same thing as novel. While patents require novelty, trade secrets do not have to be entirely novel to qualify for protection. The key is the ease to which information can be duplicated through some proper means. If the information can be readily duplicated without involving considerable time, effort, or expense, then it is not a trade secret. And fourth, what are reasonable efforts to maintain secrecy? The final element of a trade secret is that the trade secret holder maintains reasonable efforts to keep the trade secret secret. This is conceptually similar to the idea of abandonment in trademark law. When a trademark owner ceases to use a mark and does not have an intent to resume using the mark in the reasonably foreseeable future, that mark is considered to be abandoned. And once abandoned, the mark returns to the public domain and may be appropriated lawfully by others in the marketplace for their use. Similarly, when a trade secret owner fails to treat the secret information as a trade secret by not making reasonable efforts to maintain secrecy, that information loses its status as a trade secret. For this reason, it is critical for trade secret holders to develop and implement a trade secret protection plan. The purpose of such a plan is not only to demonstrate that the owner values the information through their efforts to maintain its secrecy, but also that such a plan makes any unauthorized acquisition, use, or disclosure of the secret more likely to be wrongful misappropriation because the person who took that trade secret violated the efforts to keep it secret and keep it safe.